Welcome to EI Legal's video on the difference between independent contractors and employees. I'm Sophie Tallis, a workplace relations consultant with EI Legal. If a company has a vacancy to fill within its organisation, it has the choice of engaging either an employee or an independent contractor to perform the role. There are various reasons why a company might want to engage someone to work in the business as an independent contractor. For example, they require less in-house administration than the engagement of an employee, and the contract between the parties can be drafted to specify exactly what service the independent contractor is required to perform, the time frame in which they should perform the service, and the means and resources of how the project will be completed. In addition, independent contractors are often highly skilled in their field, and a company can benefit from their expertise during a specified project. However, it is crucial for a company to be clear about whether it is engaging a person as an independent contractor or as an employee. An independent contractor is legally defined as a person who is engaged under a contract for service, as opposed to an employee who is employed under a contract of service. There are a number of factors that must be taken into account when determining whether a company is engaging an employee as opposed to an independent contractor. The full range of factors must be carefully considered. So, what are the main differential factors to consider? Independent contractors generally are engaged in a commercial relationship with a company. They're paid for results achieved, provide all or most of their own materials and equipment to complete the work, are free to delegate work to others, have relative freedom in the way that they work, do not have to provide services on an exclusive basis, are free to accept or reject work proposals as they choose, are in a position to make a profit or a loss, and are generally responsible for payment of their own tax. These factors need to be compared with a contract with an employee, who generally is engaged in an employment relationship with a company. They are paid for time worked, with the employer deducting income tax, are in receipt of paid leave entitlements, such as annual leave, long service leave, and personal leave. They are not responsible for providing materials or equipment required to do the job. They provide personal service. They work set hours detailed by an agreement, award, or contractor employment, and they do not have to take commercial risks and cannot make a profit or loss. A contract for the engagement of an independent contractor to perform services for a company should clearly define the rights and responsibilities of the parties, as well as the expected outcomes of both parties. In addition to the factors previously mentioned, terms that need to be considered and defined in a contract when employing an independent contractor are: 1. The tax position. Will the contractor be responsible for paying their own tax? 2. Insurance. Contractors will generally be responsible for their own insurance cover, such as liability insurance and workers' compensation, accident and illness cover. The company's insurance policies should also be checked to see what, if any, cover extends to services performed by independent contractors. 3. Superannuation. Generally, a company does not have to pay superannuation to an independent contractor. However, there are specific circumstances when a company will have to pay superannuation to an independent contractor, such as when they are a deemed employee. 4. Dispute resolution. It is important to include a dispute resolution clause in the contract between an independent contractor and the company. It is advised that in the event of a dispute with an independent contractor, the company should attempt to resolve the matter directly with the contractor or consider alternative dispute resolution options. 5. Intellectual property rights. Intellectual property created by an independent contractor for a company is by law considered the property of the independent contractor, unless otherwise stated in the contract. The contract between the independent contractor and company should clearly outline ownership of any intellectual property rights resulting from the work. 6. Payment terms. Payment to the independent contractor may be made on the basis of completion of a specific project or for payment of hours worked. Generally, an invoice will be issued by the independent contractor, and the method and timing of payment should be specifically defined. 7. Provision of tools and equipment. Subject to the conditions of the project the independent contractor is required to perform, they will generally utilise their own equipment. 8. Termination terms. These should specify how the contract will come to an end. When a company attempts to disguise its relationship with an employee as an independent contractor agreement, this can result in the relationship being deemed a sham contract. Consequently, the person may be entitled to receive various entitlements, such as superannuation, paid annual leave and paid sick leave. The Fair Work Act prohibits sham contracts, where an employer treats an employee as an independent contractor in order to avoid having to meet its obligations to that employee. A company's relationship with an employee is regulated by the Fair Work Act, which provides for minimum workplace entitlements, such as personal leave, parental leave, and minimum rates of pay. Employees may also have the right to claim unfair dismissal if a company has not fairly dismissed them from the organisation. The Act provides that an employer must not knowingly represent to a person that their contract of employment is a contract for services under which the person performs work as an independent contractor. Dismiss or threaten to dismiss an employee in order to engage them as an independent contractor to perform the same work under a contract for service. Or make a statement that the employer knows is false in order to persuade or influence an employee to enter into a contract for services under which the employee will perform the same work for the employer as an independent contractor. Penalties for sham contractor arrangements under the Fair Work Act include injunctions, reinstatement and compensation, as well as penalties up to $33,000 for corporations. There are a number of significant differences between engaging an independent contractor as opposed to an employee. The terms of their performance of a role for the company will be different, as will the obligations that the company will have to them in return. Clear and transparent contract terms of engagement are essential in order to avoid the serious financial and administrative consequences of getting it wrong. For more information on this topic, please visit our website, or if you have any questions, please feel free to contact us on the details provided. Thank you for watching.